Hello, everyone. My name is Ann Cleveland, and I am a paralegal here at Lyles Parker. Welcome to today's webinar hosted by Texas Association for Home Care and Hospice. Today's webinar is entitled Preventing the Revocation of Your Medicare Billing Privileges. Today's presenters are both partners at Lyles Parker, Jennifer Papapanagiotou and Ashley Morgan. Jennifer Papapanagiotou practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws, and drafting a wide variety of legal arrangements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation action. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. Ashley Morgan focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ashley represents healthcare providers across the country in connection with a wide variety of health law issues, including administrative appeals of large alleged extrapolated overpayments, documentation concerns, compliance, medical board complaints, and enrollment and revocation issues. Ashley has worked with an assortment of providers, including home health companies, hospice agencies, primary care and specialty physicians, and physical therapists. Ms. Morgan is a certified professional coder and regularly assists providers in claim disputes with major payers, including Medicare and Medicaid. And now, without further ado, I present your speakers, Ashley Morgan and Jennifer Papapanagiotou.
Thank you so much, Ann, and good afternoon, everybody. Thank you so much for joining us today. We are going to be talking about preventing the revocation of your Medicare billing privileges this afternoon. Ann, go ahead and advance to the next slide, please. Just as a general disclaimer, our discussion today is generally for your information only. It does not constitute legal advice and should not be a substitute for seeking legal counsel from your attorney. Next slide, Ann. All right, so this is just an overview of what we're going to be discussing this afternoon. We're going to provide a brief background for you. We're going to talk about your reporting obligations under the regulations and some changes that were made about 2 years ago now. And we're going to review some specific new terms that were included in those new regulations. Those are listed for you: affiliations, disclosable events, and uncollected debts. We're going to then talk about new reasons that an enrollment application could be denied, new reasons that your enrollment could be revoked, including modifications to the re-enrollment bar if you are revoked, and then application changes to Medicaid and CHIP. And then we're going to finish today with some compliance challenges that are presented by the changes to the enrollment and revocation rules. All right, Ann, next slide. Okay, so just some brief background before we get into where we are today. In 2006, CMS codified enrollment requirements, the obligation to update CMS regarding changes to your status, such as things like your address, changes in ownership, etc. In 2011, there were screening categories that were identified for CMS, depending on the level of risk, high, medium, or low, and certain things that needed to be reviewed for certain types of providers. At this time, CMS also began permitting moratoriums on new enrollments. I know home health agencies are probably familiar with the moratoria that went out. There's several states. There were moratoriums on new enrollments for home health providers. At this time, I do believe there is not a moratorium in Texas for home health providers anymore. There was one for a period of time.
That is correct, Ashley. It's been over for a number of years.
Okay, I thought so. In 2015, they expanded the denial reasons for enrollment to include uncollected debts, but that was for just enrollment applications. And then in 2016, they issued proposed regulations, and it was an expansion of the reporting requirements, revocation reasons, and denial reasons. And these sat for a very, very long time without any action, without anybody, moving them through into an actual new regulation. This was not finalized until November of 2019. And actually, the actual effective date was March of 2020. There was an issue with them communicating the final rule to Congress, so that moved back the effective date. So the actually effective date of the new regulations is in March of 2020. And that's going to be the scope really of what we're talking about today. We're going to be talking about the changes that were made to the enrollment and revocation rules by this new regulation. Okay, Ann, do you want to go ahead and go to the next slide? Okay, so when CMS issued these new enrollment and revocation rules, they stated that they thought that the new rules could result in an additional 2,600 additional revocations a year, which would save $4.16 billion over a 10-year period. So that's a pretty significant amount of money that they believe that the agency could save by having this new revocation authority. In addition, the new re-enrollment and reapplication bar would save over $1.79 billion over a 10-year period, with an estimate that it will save a total of $20.7 billion over 5 years due to the new affiliation, disclosure, and revocation authority, which we're going to talk about a little bit later in today's presentation. So some pretty significant numbers that they propose that they believe that the agency is going to save by having this authority to, prevent new enrollments, to revoke providers for new reasons. And it just really gives them a lot more authority. So let's go ahead to the next slide. Okay, so there are new reporting obligations under these new rules. This will actually be phased in after CMS issues its new enrollment forms. The new enrollment forms were supposed to be released in March of 2021. That has come and passed, obviously. They said, in March 2021, they said it would be at least another year. It has been a year now, since March 2022. We still don't have those new enrollment forms as of this month. So there's still no way for you to actually report on those new enrollment forms any of this new information yet. That is coming. So I wouldn't, just ignore this information. They are going to issue these new forms. We just do not have them yet. Regardless, one of the big things here under the new reporting obligation is going to be reporting affiliations and disclosable events. And right now, even though you wouldn't have to report it on a new enrollment application, for example, if CMS or your Medicare administrative contractor requests, and they have the authority to request this information from you, you must report any direct or indirect owner or managing employee of your company that has an affiliation with any other Medicare, Medicaid, or CHIP provider or supplier in the past 5 years that has a disclosable event. And we're going to go through a lot of these terms that are in red. We're going to go through and specifically break those down over the next few slides. But they are going to want to know, in regard to the disclosable event, you have to report it if there was a reason that you knew or reasonably should have known the information. And then the agency has the discretion to determine whether or not that disclosable event poses an undue risk. And if they think that it does pose an undue risk, then they can revoke your enrollment, or they could deny your enrollment application if you're submitting a new application and they request that information from you. So this is a very broad discussion of this, and we're going to go ahead and move on excuse me, to the next slide, and we'll break down some of these terms so that we can really understand what's required. So the first term here is affiliation. So what does affiliation mean? You're going to be determining if an owner or a managing employee has any, they want to know if you have an affiliation with any of your owners or managing employees. The owners and managing employees are defined as anybody with a 5% or greater direct or indirect ownership interest in your healthcare organization. This includes general or limited partnership interest. It includes people with operational or managerial control over the day-to-day operations of your organizations. Your administrators do fall into this category because they are exercising control over your day-to-day operations. And it would also include officers or directors of another organization or anyone with a reassignment relationship within another organization. These are
Ashley, this is Jennifer. Just to be clear, let's go back to that slide for a second. What they're looking for is you're going to take the owners and managing employees of the reporting provider, so your agency, and they're going to say, what else do those owners or managing employees have an interest in? Are they a 5% owner of any other organization that's enrolled in Medicare or Medicaid? Are they an administrator or have some kind of managed employee role in another Medicare or Medicaid enrolled provider? And what's important here is it's taking your list of owners and managing employees and asking what else have they been involved in out there in the world, right? That falls into this category of owners and managing employees. So you're looking for the overlap between your owners and managing employees and where else have they been an owner or managing employee.
Yes, thank you, Jennifer. And I also wanted to note that you are looking, there's a time period to this. You're going to be looking for affiliations that these individuals have had within the last 5 years. So if you're not currently doing this, I recommend that you, start compiling a list of your owners and managing employees and looking at their affiliations over the past 5 years in the event, these you get a request, you want to have that information available. But there is, it is a significant ask because it's not just, the owners, it's also any of your managing employees. Okay, and we can go to the next slide. Okay, so the next key term is a disclosable event. So if you have affiliations, after you determine what your affiliations are, you have to determine if those affiliations or the affiliated providers or suppliers have any disclosable events. And the disclosable events, a big one, is a current uncollected debt to Medicare, Medicaid, or CHIP, regardless of the amount, repayment status, or appeal status. So, for example, and we're going to talk about uncollected debts more later on, but just for example, if you have an administrator who maybe was an administrator at a prior agency or previously owned an agency that may still be current or still has a current uncollected debt, that would be a reportable event. So that's an important thing to know because that does happen, where, there is a significant debt maybe as a result of a UPIC audit. And even if that, UPIC audit is still under appeal, that would still be considered a disclosable event. Additional disclosable events would be any payment suspension, regardless of when it occurred or was imposed, any payment suspension under the federal health care program. And then also if they've been excluded by the OIG from Medicare, Medicaid, or CHIP, regardless of the appeal status or when it was imposed, or if they have had their Medicare, Medicaid, or CHIP enrollment, just their enrollment denied, or if they've been revoked or terminated, regardless of the reason, the appeal status, when it occurred. And this also includes termination that was done to avoid revocation. And it's important to note that except for overpayments, these do not have time limits on them. So for example, for an uncollected debt, it has to be a current debt of the affiliated entity. So you're going to identify your affiliations in the last 5 years, and then you're supposed to be contacting those affiliations to ask if they have any current or uncollected debts. Even if the affiliation no longer exists, even if you have had that affiliation in the past 5 years, that would still be a reportable, disclosable event. For suspensions, exclusions, or revocations, you would have to identify your affiliations in the last 5 years and then disclose if there has ever been a payment suspension, even if, you weren't there, if it happened. So for example, if your administrator used to be at another agency that has had a payment suspension imposed on it before, that even if it was when they weren't there, that theoretically that would be a disclosable event under these reporting rules. So they are very broad, and I think it might be difficult to probably identify some of this information, but we just want to make sure you all do have the information available and what currently under the regulations they're going to be asking for. This could look different when they finally release those new enrollment applications. Again, we don't have those yet, but that is how the rules are currently defined.
This is Jennifer. Yeah, I would just add, this is what the reg says. How this ultimately gets implemented and what CMS decides they're going to focus on, it's still open. I think we're not going to know that until we get the new enrollment forms and we get additional guidance from CMS in the form of changes to the Program Integrity Manual chapter on enrollment. For right now, we really don't have a lot of guidance, although these rules exist and they can use them today to take action and to impose revocations. So again, we strongly recommend that for your existing owners and managing employees, you start collecting this affiliation data and start asking these questions so you can do some pre-planning if you do find an issue.
Yeah, I agree. And thank you. Okay, so the next key term is that uncollected debt. So for reporting under the regulation, this term means any Medicare, Medicaid, or CHIP overpayment for which CMS or the state has sent notice of the debt to the affiliated provider or supplier. It does not include audit requests or routine denial letters where refunds are made through remittance advices or claim corrections, but it does include a demand letter or other formal requests for payment. So, like I was saying before, if you were under a UPIC audit and there was a demand letter that was issued in connection with that UPIC audit, that would be and it hasn't been repaid, that would be an uncollected debt. In addition, they also consider civil money penalties that are imposed under the CMS regulations and assessments that are imposed under the Medicare regulations. This is really important. There's still a lot of uncertainty, I would say, about uncollected debts and how to deal with those for providers who have been under a UPIC audit and that might have a large extrapolated overpayment. This is a big deal. We get lots and lots of questions from providers that have gone through overpayment appeals and have large debts that they really theoretically cannot, overpay, and how are they supposed to deal with that, because it could impact their ability to, participate in the program. And there are still a lot of questions about really how CMS is going to treat all of this. Bankruptcy does seem to remain an option to discharge these debts that are owed by companies. There's still many uncertainties with that. We do have, clients that are pursuing that option, but we're still, early in this process. So we don't have a lot of feedback from the agency about how they're going to interpret that, and if they are going to, consider a debt that is discharged through bankruptcy no longer an uncollected debt that would be reportable. It does seem like that is the way to discharge a debt, but again, we have clients that are early in this process, and we don't have tons of feedback from the agency. And I would say, if you have an entity that has an overpayment but it's shut down, it might be worthwhile to speak with your counsel regarding how to manage that risk, because there is, some questions about what a current uncollected debt is, and whether, the company is still in operation or not may play into the time period for uncollected debts, that 5-year period.
Right. This is Jennifer. I would just add to that what we're seeing and what the guidance has always been from CMS is that while you're in the appeal process for something like a UPIC overpayment, they're likely not going to take action against anyone to revoke them, because they understand that process, can take a long time. And while you're in the appeal process, you've got certain rights, and the debt really isn't final. That being said, it doesn't mean it's not reportable on an enrollment application if they ask you for the information. So you can get caught in a really weird situation where when they ultimately change these enrollment forms, you might have to report an uncollected debt that's under appeal, and they could arguably, if you failed to report it, they could take action for failure to report, even if they would not have otherwise taken action related to the uncollected debt that was under appeal. So, you know, there are a million different ways this can go off the rails, and our suggestion is that you talk to counsel and make sure you understand in your specific scenario what your requirements are and, you know, how to best manage your situation.
That's exactly right. And that plays in, Jennifer, too. And if we could go to the next slide, the discussion of an undue risk. Because when you report this information, if you, for example, you're a new agency enrolling and you're reporting this information on the new enrollment applications that we don't have yet, if you are reporting it, CMS is going to assess whether there is an undue risk, and they're going to decide whether or not they can deny that enrollment application. Similarly, you know, if they request that information from you right now, which they are fully entitled to do, as I stated before, they will determine whether there is an undue risk and whether they will revoke you based on that information. And the factors that they're going to utilize in determining whether there is, in fact, an undue risk is going to be the duration of the affiliation, whether or not the affiliation is current or terminated, and if it was terminated, when was that terminated? So that's why we keep saying, you know, it's important to identify those affiliations now, and then after you identify your affiliations, identify whether there are any disclosable events, and if necessary, you need to take action now, because they are going to look at when that affiliation was terminated, if it was terminated, the degree and the extent of the affiliation, and the reason that you terminated the affiliation, the type of action that is disclosed, when it occurred, if it's an uncollected debt. They're specifically going to be looking at the amount involved, whether or not you are in an extended repayment, or whoever owes the debt, whether or not it's in an extended repayment plan or being repaid, to whom the debt is owed to, and then, of course, our favorite catch-all, anything else they think is relevant. So, like Jennifer said, if you have an affiliation, if you have somebody that has an affiliation with another company that does owe an uncollected debt, you are going to need to report that information. Theoretically, you know, if CMS is reviewing this and they see that it's in a repayment plan, you know, I would like to hope that they wouldn't take action against you based on that if, you know, it's current and it's being repaid, but we don't know, because we haven't seen a lot of action on this specific issue yet, but that is the information that they're going to be asking. So when you are collecting this information about a disclosable event, if somebody does have an affiliation with an entity that has an uncollected debt, I would make sure you get those specific pieces of information about the debt, you know, the amount, whether it's currently in repayment, and who they owe the debt to as well.
This is Jennifer. This brings up a really interesting scenario, because the vast majority of this information that providers are going to be asked to gather is not publicly available. So you really are having to rely on the people at these other affiliated providers, whether they're current or previous affiliations, to tell you, to be transparent. And it's going to be really interesting to see how CMS applies that new or should reasonably have known standard for what you have to report. Again, we don't have guidance on that yet, but we're hoping once they get around to promulgating the new forms that they're going to give us that guidance.
Thank you. There we go. Okay, so here's some tips for you all to try to manage your risks. If you are an organization that has multiple provider numbers, you need to track all of your provider numbers. You need to, for each of those provider numbers, you need to know who the owners are, you need to know who the managing employees are, and you need to identify any problematic affiliations for all of those provider numbers. Again, there is no reporting obligation yet. There is still a risk for revocation, because CMS can request this information at its leisure. And, you know, we have been told that the enrollment applications are coming. They're not here yet, but we are expecting them on the horizon. If you do identify any owners or managing employees that have a problematic affiliation, we suggest that, you know, you proceed with removing that owner or managing employee if you do determine in your own calculation that they present an undue risk to your company. If you have any overpayments, or if you are with a company that currently has an overpayment, definitely appeal that overpayment as long as you can through the administrative appeals process, or repay the overpayments that are owed. It's really important. You can't just let those sit out there because that could have an impact on your enrollment ability. You could have your enrollment application denied, or you could be revoked. There are opportunities to enter into extended repayment plans with CMS for up to 60 months. You have to submit quite a bit of financial information when entering into those agreements, but those are possible. We have clients that have those in place. And again, bankruptcy is a potential option, but this does have a cost, and it does require a lot of careful analysis and planning. And again, if you are shut down, I would talk to counsel. Just being shut down is not going to absolve you of these, reporting obligations, because the debt is still going to be out there. So you really want to have a conversation with your counsel about, if you're shut down, does that mean that you are, how long does the debt remain current, et cetera. And next slide. Okay. These are a list of the current enrollment denial reasons. So before the new regulation was released, the 11 that we have at the top, they could already deny an enrollment application based on, you'll see that we have number 7 in red. That one was actually modified by the new regulation. And then they added 3 additional enrollment denial reasons, and those are if you were revoked under a different name, numerical identifier, or business identity, and the re-enrollment bar has not expired, if you have an affiliation that poses an undue risk, or other program termination or suspension. And we're just going to cover a few of these. We're not going to cover all of the ones that were previously in existence. We're just going to touch on number 7 and 12 through 14. Anne? Okay. So the first one we're going to talk about is a current payment suspension. So this previously only applied to Medicare suspensions of owners, physicians, and non-physician practitioners. The new regulation actually expanded this to include Medicaid suspensions, and now it includes all provider and supplier types in addition to managing employees. So you'll see in red here, it says CMS may apply this provision to this provider or supplier under any of the provider, supplier, or owning or managing employees, or the organization's current or former names, numerical identifiers, or business identities, or to any of its existing enrollment. So really expanded the scope of their authority to deny an enrollment application based on a payment suspension here. So if you are starting a new agency, you will need to evaluate this before you submit an application, or it could be denied. And again, when you're submitting these enrollment applications, it's really important that you have a lot of thought process that goes into what you are reporting on that application, because your enrollment application can also be denied for the failure to report information. So you want to make sure you're accurately describing this information when you submit that enrollment application. It is, a document that you attest to its accuracy, and you don't want Medicare coming back and saying that you failed to disclose information to them. So it's important that if you evaluate your affiliations and you determine whether or not those affiliations have a current payment suspension that might need to be disclosed if you are an agency that's issuing a new enrollment application. Next slide. If you are revoked under a different name, numerical identifier, or business identity, and there is a re-enrollment bar that has not expired, then they can deny your enrollment application. So this essentially means that if they determine that there is a similar managing employee, or if there's the same, geographic location, if it's the same address, they could look at the provider or supplier type, the business structure, or really any information or evidence that could indicate that the two parties are similar, or that the provider supplier was created to circumvent the revocation or re-enrollment bar, then they could deny your enrollment application. They issued this as a denial reason and as a revocation reason because they were trying to look for straw owners or managing employees where possible associates or family members or other individuals were posing as the owner on behalf of the persons who actually operate or profit from the business. So they're trying to prevent, people who have previously been identified as problematic from re-entering the program under a straw owner. So they're going to be conducting a thorough analysis to determine, whether there are any similarities between currently revoked providers, and they can deny your enrollment application based on this. And they do not have to show undue risk in determining that in denying your enrollment application if, when they investigate, they determine that you are revoked under a different name, MPI, or tax ID. Okay, next slide. And then the last two would be if they can deny your enrollment application, again, if they determine that any of your affiliations pose an undue risk. So again, after you conduct your review of your affiliations, if CMS determines that any of those affiliations that you have does pose an undue risk of fraud, waste, or abuse, and again, we discussed what the factors are for undue risk are, then they can deny that enrollment application. This again, ties back to that definition of a reportable affiliation and those disclosable events. And CMS can take action based on its own data before they, make this request from you. Like if they have information on their side that shows that you do have an affiliation that poses an undue risk, then they can just take their own action. But this will be something that you need to report moving forward when we get those new enrollment new enrollment applications, and you could have your application denied because of this. So it's important again to go ahead and start evaluating those affiliations and disclosable events if you have not already. And the last new enrollment denial reason would be any other program termination or suspension. So if the provider or supplier is currently terminated or suspended from participation in a state Medicaid program or any other federal healthcare program, for example, CHIP, or if your license is currently revoked or suspended in a state other than the one that it's currently enrolled in, then they can deny your enrollment application. Previously, they would only deny for a license revocation or suspension if it's in the same state. So if you are an agency that has, multiple locations, if you have, a location in another state and there is a suspension, in another state, that is something that theoretically they could deny an enrollment application for. And CMS will consider the reason for the termination or suspension, whether there is more than one action, and of course, their catch-all, any other information that they deem to be relevant.
This is Jennifer. I'll just chime in briefly. We don't see this much in home health and hospice, other than the state Medicaid program termination issue, or any other federal healthcare program termination, but it is very common with physicians who are licensed in multiple states. So it used to be that they basically only looked at the state where you're enrolled, and if you had a license, they'd let you stay in the program. They've now very much broadly, we've actually seen this happen. If a physician's licensed in 4 different states and he gets into trouble in one state, they'll go and immediately revoke all their Medicare enrollments in all jurisdictions. So it's maybe not as important to home health and hospice, but definitely affects other kinds of practitioners.
Yeah, I agree. And I would also just say, we are seeing increased communication too between the feds and between the states as well. So they're trying to, make sure that information is passing through and, so that they can take action as necessary. Next slide. Okay. Reapplication bar. So under the old regulations, there was not a reapplication bar that might prevent a provider who had their enrollment application denied from reapplying. So, you could just submit an enrollment application. If they denied it, you could just submit another one. That has now changed. CMS now has the authority to prohibit a prospective provider or supplier from from submitting another enrollment application for up to 3 years if its enrollment application is denied because CMS believes that the provider or supplier submitted false or misleading information on or with or omitted information from its application in order to gain enrollment in the Medicare program. And I want to point out, that they're talking about false or misleading information. CMS has a lot of authority. They have a lot of discretion. A lot of times, in my opinion, CMS kind of interprets incorrect as false. So that's why, again, it's really critical that you evaluate all of the information that you're putting down on an enrollment application. You're making sure that you're properly disclosing all the information. For example, if you have any final adverse actions that need to be reported when these new enrollment applications come out, that information about affiliations needs to be accurate, because you do not want CMS to review your application, determine that you failed to submit certain information, and then have them take action and deny that enrollment application and say that you submitted false or misleading information, and now we are prohibiting you from submitting another application for 3 years due to that failure. So it's really critical that you are reviewing those applications. I would recommend working with counsel when you're submitting a new enrollment application to make sure you're accurately identifying the proper information. They do have some factors here for how long of a period they will impose the re-enrollment bar, but they've got that catch-all at the end. They've got any other information they deem relevant. They have a lot of authority. We haven't seen a lot of reapplication bars yet. Jennifer's going to be talking about, re-enrollment bars, and we've seen them be a lot more aggressive with those. So I would expect that if we start to see reapplication bars, I would, generally expect for them to be aggressive with the reapplication bars as well.
Thank you, Ashley. I'll just add, I've certainly seen situations in the last 2 years where they could have applied a reapplication bar because a provider failed to disclose some information that they should have, but they haven't done it as of now. They've generally revoked people or denied them on whatever basis, another basis, and have not applied a reapplication bar. Even if and they don't generally use, a denial reason if you submitted false or misleading info. Usually they've got another reason to rely on. That being said, it does exist. It is just another way they can kind of control the who they let into the program and who they don't. So let's go ahead and go to the next slide. I'm going to quickly touch on the new revocation reasons. Again, like we did in the denial reasons, I've highlighted in red the ones that have changed. These were the existing revocation reasons before the new reg was finalized. There were 14 of them. 2 of them had some significant changes that was failure to report in Medicaid termination. For home health and hospice, the most common revocation reasons we saw before 2020 were number 4, 5, and 10. So false or misleading info, on-site review, that's, basically you moved and didn't tell them and they sent a site inspector and they couldn't find you and they would revoke for that. And then failure to document or provide CMS access to documentation. Those were the most common ones we saw. We, interestingly enough, over the last 2 years, basically during COVID, since that started, the numbers of home health and hospice revocations has gone down in our experience, and we do a lot of revocation work. There was a suspension of a lot of enforcement activity for the first year of COVID. That has ramped back up. They are conducting surveys again. They are certainly in full swing on the enrollment and enrollment enforcement side. So it can just be a cyclical thing where they're focused on other kinds of provider types and other certain revocation reasons. We've certainly seen a lot of revocations based on felony convictions. Certain other reasons have been more common during the last couple of years. But it's always difficult to predict, in advance sort of what they're going to focus on. We don't get a lot of feedback, unfortunately. And I think internally they've been really focused on managing COVID and how to oversee the enrollment process and the revocation and appeal process during COVID, and that sort of slowed things down. So let's go to the next slide. New revocation reasons that they are implementing after the November 2019 reg are these 5. The ones I've bolded: referral to Treasury, revoked under a different name, affiliation, and billing from a non-compliant location are the ones we're going to focus on because they're the ones that are really more potentially applicable to home health and hospice. The last one, abusive ordering, really is more focused on practitioners that order services. So it could affect a physician or a non-physician practitioner, but it's unlikely to affect your home health or hospice agency. So let's go to the next slide. So as I said, there were 2 modified revocation reasons: failure to report and Medicaid termination. The failure to report reason, in the past, it let CMS revoke if a Part B provider failed to report a change in practice location or a final adverse action within 30 days. Now they can revoke, they have the regulatory authority to revoke for failure to report timely any change to information on an enrollment form. And there are reporting obligations outlined in the regs. They'll tell you exactly when certain information has to be reported and what the deadline for that is. So you have to have a process in place to keep your enrollment data current. Right now, when I counsel clients, I advise them at a minimum, you need to review your enrollment information every 90 days. Because unless you have an adverse action or you have some kind of more significant change, like a change in ownership, most reporting obligations, you have a 90-day window to report the information, and that includes a change of location. So in general, unless you have a major event, if you're reviewing your enrollment information every 90 days and you're making sure it stays up to date and you're submitting those reports timely, you should never have a problem with failure to report. The new revised regulation, there have been some updates to the what we call the Program Integrity Manual, which is sort of the implementation manual for enrollment for CMS. It's a specific chapter within that manual. They did another round of updates in March of this year, and right now the failure to report revocation reason still is only focused on practice locations and final adverse actions. They have not instructed the contractors to take any kind of action if you report information late. So my advice to folks is, there's a big revalidation effort going on right now. Everybody that got paused for revalidation while COVID was going on is now being given new revalidation dates. They're having to submit new information. And I get calls probably, once or twice a week saying, oh my gosh, we forgot to report something and we're late, and is this going to be a disaster? And my response to everybody is no, likely not. Do your revalidation, or if you're not due for revalidation, submit your update, do it now. And assuming it's not a reason, you're not reporting something that would otherwise get you revoked, you're going to be fine. But don't not report something because you're afraid that they're going to do something. If you have a concern about something you're going to report, and whether or not it's going to have a negative impact, contact your counsel and talk it through with them. And chances are it's probably not going to be an issue, and you just need to do it and get it pushed through and make sure your enrollment record is up to speed. And then once it is, review that every 90 days to make sure it stays in order. They do have, like I said, the regulatory authority to revoke you for failure to report, and they've got some factors they will consider that were actually written into the regulation. But again, we're not seeing people revoke for late reporting unless it would otherwise result in a revocation. So for example, if what you're reporting is an adverse action that one of your owners was convicted of a felony, that can get you revoked. There are ways to manage that, and I highly recommend you talk to counsel if you find yourself in a situation where you're having to report an adverse action, because there are things you can do in advance that might assist you and prevent you from getting into a situation where you're having to deal with a revocation. The other modified revocation reason was for Medicaid termination. Previously, they would only permit revocation for Medicare if Medicaid was revoked. They are now expanding that to include any federal healthcare program termination or revocation. So for example, CHIP or any other federally funded program that has some kind of enrollment obligation. They do have to wait until the appeal rights under that other program are completely exhausted before Medicare can take action, but it can be applied to an existing provider or supplier of Medicare under any of its current or former names, numerical identifiers, or business identities. So if you had an old agency that got terminated by Medicaid, and you've got what appears to Medicare to just be a recreation of that business, they could take action against it based on that Medicaid termination. This is really just Medicare trying to plug some holes that they're very much interested in keeping what they view to be bad actors out of the program. And I'm not making a value judgment about that. I'm just saying that's their goal. That is their policy perspective on it, is that we don't want to allow individuals or providers that have a bad track record with the program from continuing to bill and collect money from the program. That's sort of their policy perspective on this. So let's go to the next slide. All right, so new revocation reasons. This first one gave Ashley and I quite a bit of heartburn, because when we saw it, and given the experience we have, they've given themselves the authority to revoke providers who have a debt referred to Treasury. Well, MACs, Medicare Administrative Contractors, refer debts to Treasury all the time and don't do it appropriately. I mean, I think if Ashley had to count up the number of letters she writes a month to tell a MAC to recall a debt from Treasury, she'd run out of fingers. They refer stuff all the time when they're not supposed to. And it's really important, if a provider gets one of these, we intend to refer a debt to Treasury letters from a MAC, that you get in touch with your counsel quickly, because there is a way, and we can and we do all the time, either stop those from happening or get them called back. We don't want a debt referred to Treasury if it shouldn't be, because the last thing you want is an inappropriate referral that then results in a revocation, and then you've got to appeal it and try to explain to CMS why the referral was inappropriate. And that's really the only remedy you have if you've gotten to the point where you revoke. The good news is we haven't seen any revocations based on this reason yet. And this is an easy one for them to use, because it's a very black and white thing. Either it's been referred appropriately or it hasn't. And there are factors that they've given themselves so they don't have to automatically revoke you. But I would suspect, in my experience, when CMS has factors, it's just another way for them to revoke you and really undermine your ability to appeal the revocation, because they get to decide. It's discretionary. And as you can see, this list of factors includes any other evidence it thinks is relevant. So yeah, there are factors. And if when they revoke, if they do a bad job of describing in their communication why they thought the factors existed to justify their action, Ashley and I this is where we make our money, is we attack their application of the factors, or the fact that they didn't really apply them at all. But generally speaking, they're getting better and better at articulating why they take certain actions if there are factors they need to have demonstrated they applied in a particular situation. So discretionary decisions by CMS are the hardest to appeal, because generally speaking, the administrative law judges that handle revocation appeals they defer in all cases to CMS, and will generally, allow a revocation to stand if CMS can show just even the barest amount of evidence that they considered factors and exercise their discretion. So again, we're not seeing a lot of revocations based on this reason, but we are getting a lot of questions about it. And I do strongly recommend providers, if you have an outstanding overpayment and you can't pay it back, or you owned a company sometime in the past 5 years that has an overpayment that hasn't been repaid, and maybe it's been referred to Treasury or it's still tied up in the appeal process, reach out to your counsel and talk about how to manage that. Because if you have another business that's currently enrolled in Medicare, it can affect it. And Ashley and I probably spend, we answer more questions and talk to more clients about how to manage the enrollment risk associated with overpayments than almost any other kind of enrollment question we get. So, you know, we're working with clients who are considering bankruptcy to get rid of old debts. We're working with clients that want to enter into extended repayment plans. We work with clients that want, you know, depending on where they are in the appeals process, they want to look at settlement conference facilitation to try to reduce debt. You know, there are a lot of options out there where we can try to help clients who find themselves in these situations, but this is not the time to DIY it. You need representation, you need help, and somebody who has experience in these areas if you are looking at trying to manage one of these situations. So let's go to the next slide. So another new revocation reason, which Ashley touched on this under the denial reasons, is they can revoke an existing enrolled provider if they believe that it is basically a straw man or a reinvention of an existing or an earlier provider that was revoked. So if, and I actually had a case that looked very much like this early on when this regulation was implemented. CMS, as Ashley said, is trying to stop people from opening up new providers or suppliers to replace a revoked entity, and that's what this reg is intended to prevent. It used to be 10 years ago, if something went off the rails and a home health or hospice provider had a huge overpayment that they could never repay, they would shut it down and they'd go out and buy a new one. And they deal with the old one as best they could, or maybe they wouldn't, and they just resume doing business under the new one. And CMS was aware that that was going on, and they didn't like it. And so that's why they apologize for the barking. This is the hazards of working from home. They've plugged the hole, and they are now essentially saying, if you look like you're a recreation or a replacement for an earlier revoked entity, we can kick you out. And they're going to look at these factors to investigate the degree of commonality between a previously revoked entity and a currently enrolled one. And they're going to look at, you know, how much overlap is there in the owning and managing employees? Is the geographic location the same or very similar? Is it the same provider or supplier type? What does the business structure look like? And any other evidence they think is relevant that might demonstrate that the two parties are similar to each other, and that it was created, the new one was created to circumvent the revocation or re-enrollment bar. Note, this does not require showing of undue risk. So this is not like an affiliation analysis. This is just, we're looking to see if a new entity that's been enrolled looks a whole lot like an old entity. And if so, and that old entity had a revocation and a re-enrollment bar, and that bar hasn't expired, they can take action against the new one that's currently enrolled. Let's go to the next slide. Okay, affiliations that pose an undue risk. Obviously, this is a new revocation reason. Ashley talked about this in the context of denials of applications. It ties back obviously to the definition of reportable affiliation that we talked about earlier. And as Ashley said, CMS can take action and revoke based on its own data before it makes any request for disclosure of affiliation. I actually had a revocation based on this reason very, very early on after the reg was finalized. And it was a scenario where a home health agency existing enrollment was revoked based on the owner's affiliation with an agency she had owned 2 years prior that had been revoked. So, I mean, it fell squarely into the affiliation concept and fit within that regulation. We got it thrown out on other grounds because of the effective date of the regulation. But they did have a legitimate basis. The regulation itself just was problematic, and the effective date was problematic. So, I mean, we got it thrown out on a technicality. But if this had happened now and the same facts were presented, I don't know that we would have been successful in getting it thrown out, because frankly, they had all the right facts in CMS's favor to impose the revocation. So let's go to the next slide. Billing from a non-compliant location. This is, you know, this is one of those where I think this was originally conceived of to address a very specific situation involving DME. In its commentary on the final rule, CMS mentions situations where DME sites are enrolled in multiple states, but for whatever reason, there's no activity at one of the locations. There used to be an old strategy where DME providers would go set up an office in each state where they wanted to provide services, and they would kind of park the office in one state in order to take advantage of the reimbursement rate or to be able to deliver services to that people in that particular location. But they didn't want to actually put any people there. They didn't want to actually incur much expense there. And so they would service that geographic location from an office in another state. And CMS said, you know, that's a non-compliant location because you're not actually delivering service out of the office that you've reported and enrolled, and they want to be able to revoke those locations. What's important and interesting here is we've got an existing regulatory authority, and it's written into the regulation for hospice that you have to be fully approved as an alternate delivery site from a licensure perspective and from a Medicare certification perspective before you render services to Medicare beneficiaries. And I can tell you from personal experience that lots and lots and lots and lots of hospice providers start rendering services before all those boxes are checked. I certainly, you know, it's just reality of operations. Now, I counsel clients all the time about how to do this the right way. And, but I also have found situations where, you know, existing organizations, especially large organizations, find themselves in a scenario where, well, we got it licensed as an alternate delivery site for our hospice, but, you know, we haven't really finished the Medicare application process yet. You know, we're paying on the lease and there's people there, and, you know, it's a real gray area whether they're delivering services out of that alternate delivery site yet. The reality is CMS could use this regulation to revoke the whole company based on billing from a non-compliant location. So my advice is that you need to be paying attention to home health branch locations, alternate delivery sites, and those drop sites or administrative sites, and be sure they're appropriately enrolled and that the enrollment matches the actual activity that's going on at that location. You know, this is, most people are getting it right, but I do see scenarios and folks that come to me with questions about, you know, how do I navigate the gray area of what is a drop site and what is not, and when I have to have enrolled and when I don't, and when I can start rendering services and when I shouldn't be. So, you know, this is the kind of scenario where, you know, it's sort of a kind of some circumstances analysis, and we often end up discussing specific scenarios with the regulators to get their input on it. So I'm not, again, I haven't seen this applied to anybody yet, but you should be aware that it exists. Let's go to the next slide. We're running a little short on time, and I want to make sure we get to our compliance portion of this so we can give you some tips and other observations we have. But be aware there were modifications to the re-enrollment bar. It used to be that the longest re-enrollment bar they would have imposed was 3 years. And we had specific guidelines for certain revocation reasons. That would be 1 year, or they'd be 2 years, or they'd be 3 years based on what the revocation basis was. Now they have largely eliminated the guidance that we used to have for how long a bar would be for a particular revocation reason. All they say now is it can be up to 10 years for a first-time revocation, and they can decide how long the bar is. They're already imposing 10-year bars very liberally in felony conviction cases and in failure to respond to documentation scenarios. We are generally seeing longer re-enrollment bars for all revocations. Something that used to be a year is now 3 years. That doesn't surprise me. That is a policy decision by CMS, and they have absolute discretion to decide how long the re-enrollment bar is. And I will warn you in advance that the re-enrollment bar and how long it is not an appealable determination. CMS decides, and that's it. So unless you overturn the revocation altogether or negotiate something different through the appeal process with counsel for CMS, you're going to be stuck with that re-enrollment bar. So if you come to us and say, I got revoked and they imposed this really long bar, and we talk it through and we're like, well, you don't really have a great basis to appeal the revocation, but we might be able to negotiate a bar. And they're like, well, can't we just appeal the bar? The answer is no. Re-enrollment bars are not appealable. But I will say Ashley and I, over the years, have definitely been able to negotiate, and in the context of an appeal, Once it gets assigned to an attorney that's representing the government, we have been able to negotiate these re-enrollment bars. Although I will say in the last 2 years, they've become less settlement inclined with regard to bars and reversals of revocation. It's just the nature of how they're viewing these regulations now. You should be aware that if you are attempting to circumvent a re-enrollment bar, they can extend your existing bar by an additional 3 years. And if you're revoked twice, they can kick you out for up to 20 years. Factors that they're going to consider when determining the length of a re-enrollment bar are listed here. And it's everything like from the reasons, if it's a multiple revocation situation, how long it's been between those revocations, what your history of final adverse actions are, and of course, any other information that are relevant. I kind of consider the factors irrelevant, frankly, because since re-enrollment bars are not appealable, and that's written into the regulations, by the way, administrative law judges, if you try to say, I'm appealing the exercise of CMS's discretion and the setting of the re-enrollment bar in an appeal on a revocation, all the ALJ is going to say in return is, that's not an appealable determination. I can't comment on that. It is what it is. So I'm not sure the factors really mean much, but there they are. Let's go to the next slide. So the affiliation reg and these new enrollment regs apply across the board to Medicare and to Medicaid and CHIP as well. Generally, the states have been given some flexibility. They can either rely on Medicare's process to evaluate affiliations, or they can elect to do it themselves and write their own regulations, do their own data collection. Again, Texas has always had a pretty robust data collection process for Medicaid enrollment. Anybody who's been through that process knows how painful it is. Medicaid rolled out their new enrollment portal this year. I've been hassling with it for a bunch of different providers who are either going through validation or trying to make changes, or even in this case, one initial enrollment, but not for home health or hospice. It's a different provider type. And I went back and looked at the kind of disclosure questions they're asking and the data they're asking for. And while they don't directly talk about affiliation or ask the question in a way that would imply they're sort of directly adopting the Medicare criteria for reporting affiliations, they do ask questions that edge over into that area. So I'll give you an example. For Medicaid does ask in its disclosure questions on a Medicaid enrollment in Texas if a former owner transferred their ownership to a family member following a sanction, conviction, license restriction, or other monetary penalty. They also ask if that transfer or a transfer of ownership happened with knowledge of a pending sanction, conviction, license restriction, or other monetary penalty. This is sort of getting to that whole straw owner question and edging over into the kind of data collection that would look at affiliations or this sort of alter ego straw owner kind of situation. They're also asking if owners or managing employees of the existing Medicaid provider that's enrolling are employed by other providers or have a relationship with another provider. So that would lend me to believe that they're looking to see if there are other adverse actions against those other employers or other providers that, the current reporting providers, owners, and managing employees are looking, applying to see if there are other issues. Medicaid is collecting information for sure that could be used for an affiliation type analysis, even if they're not necessarily sort of following it or at least transparently applying it the way we would expect Medicare is going to apply it. Let's go to the next slide. CMS has issued some new instructions to MACs on processing provider enrollment applications that implement these new regulations. If you want to look at that for yourself, it's in Chapter 10 of the Program Integrity Manual, and I provided a link for that. Generally, Medicare administrative contractors that process enrollment applications can identify revocations, meaning scenarios that would support a revocation, but they generally can't implement them without CMS's approval. And there's a group within CMS Central Office called the PEOG, Provider Enrollment Oversight Group, that is really taking over most of the enrollment and revocation oversight. And essentially, and there were another round of updates to this particular chapter and some other chapters of other manuals that are going to move a lot of the authority for these actions away from state agencies and what has traditionally been the CMS regional office and push it over to PEOG. So we've seen that happening with over the last several years, where it used to be that certain types of appeals of revocation actions would be filed with the MAC, and over time that has changed, and almost all appeals are now filed directly with PEOG for the first level reconsideration request. And that's reflected in the program manual changes. What's interesting is that most of the new instructions in the program integrity manuals aren't giving us a lot of new information other than what was already in the regulation and the final rule that promulgated it. So we're anxiously awaiting these proposed new enrollment forms and any other new guidance CMS wants to give us on how those are going to be implemented. You can subscribe to some listservs and things through the CMS website, so you'll get notifications when there are changes to these manuals. Health lawyers subscribe to that kind of stuff. But if you're, I will say that TAHCH does a pretty good job of monitoring things like this and sending out notices to their constituents to advise them when we do see major changes and things like this. So I would advise you to keep your eye on that. And we certainly will publish articles if we see big changes to regs or guidance that affect our, our typical client base, like home health and hospice agencies. I said before, we're seeing more and more 10-year re-enrollment bars, but let's move on to the compliance challenges that we see out there based on these new denial and revocation regs. As Ashley said before, organizations that have multiple provider numbers are going to have to figure out a way to track them all, track the owners, track the managing employees, and identify problematic affiliations. You've got to keep your eye on inappropriate referrals to Treasury. Generally speaking, you don't have to worry about that unless you have an overpayment appeal that, an overpayment you're not addressing. As long as you're staying in the appeal process, you shouldn't be referred to Treasury. And if you are, you need to get with counsel and figure out how to get that fixed. We are kind of scratching our head about overlapping re-enrollment bars and look-back periods. A re-enrollment bar may be 3 years, but the owner or managing employee may be denied enrollment, or other entities may be revoked for up to 5 years. There are these overlapping timeframes, and it's going to be really complicated in some scenarios to evaluate whether an affiliation reg is a problem or not. And it's honestly, it's too complicated for providers to try to do it on their own. And so if you've got a scenario where you have owners and managing employees that do have problematic affiliations, my advice to you is get with your counsel and work it through and figure out if there's anything you need to be doing now to prevent a problem later on. An ounce of prevention is worth a pound of cure in these scenarios. You don't want to get to the point where you're revoked, because it's a mess once you get there. Let's get to the next slide. We are, again, as I said, number 4, we're anxiously awaiting CMS's guidance on what new or should have known about a reportable affiliation really means. How hard do we have to dig? What kind of due diligence are providers going to have to do on their owners and managing employees? More on that, hopefully, in the future. How is this going to affect hiring practices? How is this going to affect if you're hiring a new administrator, what kind of screening should you be doing? What kind of pre-employment information should you be collecting? You need to know their history. Where have they worked? And then once you figure out where they've worked, you got to do your due diligence on those affiliations. If your new administrator was an administrator at another home health agency, and arguably you've got to ask, did that other home health agency have a disclosable event? Do they have an uncollected overpayment? Did they ever have a revocation or a suspension? Some of those are uncomfortable questions to ask, and you could certainly ask the employee that you're looking to hire, the potential employee. But if they don't know, are you going to have to pick up the phone and call that other business and say, I'm considering hiring Mary Smith. She was previously your administrator. I need to know if your agency's ever been suspended. I'm trying to imagine how CMS is going to implement this, and what reasonably are they going to expect providers to do to collect this information on disclosable affiliations. It's going to be very interesting. As I said, for now, enrollment forms have not been revised and requests for disclosures haven't begun, but we are seeing revocations here and there that use the new reasons, although not at the level I would have expected if COVID hadn't happened. And obviously, we strongly recommend that you review your enrollment information every 90 days. And anytime there's a fundamental change, such as relocation, change of owners, or implementation of a final adverse action. Ashley, I don't know if you have anything else you want to offer as far as compliance challenges, but if you want to go to the last slide, our contact information is here. Feel free to reach out to us. I would say it's probably easiest to get us by email a lot of times. If you have a specific question and you want to reach out by phone, you're welcome to. We'll do our best to get back to you. Emails are something that Ashley and I love to answer when we have a break in between calls or meetings, or even, you know, I don't know about Ashley, but in the evening, when we find a few minutes to do that. So we're happy to stay on the line and answer questions if anybody has one for a couple minutes here. Otherwise, we very much appreciate you listening and hope you have a great rest of your day. Any questions that you see, Anne?
Yeah, we have two questions. The first question is from Romeo, and his question is, does it include an ulterior director of nursing? And I believe he sent it in when you guys were talking about affiliations.
So right now, the definition of managing employee does not look like it extends to directors of nursing. I will say it absolutely does extend to administrators. There's some language in guidance in what we call the State Operations Manual, which is the survey and certification manual for all kinds of certified providers, that includes home health, that very clearly puts administrators in that category of managing employee. And so when I enroll or update enrollment for a home health or hospice provider, I always include the administrator. So directors of nursing, as of now, I don't see them as fitting into that definition of managing employee. In most scenarios, again, your situation may be different, but in most common scenarios, they don't. Second question again? You said you had another one, I think. And maybe Anne's on mute. All right, well,
yeah.
I apologies if we missed your second question, but I will have Anne email that to Ashley and I. If for some reason you sent in a question and we didn't answer it, again, please email or call Ashley or I, and we'll be happy to answer it. Thanks, everybody.
Thank you.